Ladies and gentlemen, I never had the privilege of meeting the late Donald Macfadyen, but since receiving your very gracious invitation to participate in this lecture series organized in his honor, I made it my business to learn more about his truly stellar career, both as counsel and latterly as a judge. He was clearly a much beloved, respected, and admired Scottish icon. At the ripe age of 62, great judges are in their prime. They have accumulated and added to their knowledge and wisdom such a wealth of experience that their best work surely lies ahead. I can therefore well imagine how devastating a blow it must have been, not just to his dear widow, to you, Lady Macfadyen, and your children, but also to his colleagues, to the administration of justice, and to the people of Scotland as a whole when he lost his battle to cancer in 2008. The passage of time might ease, but can never assuage the profound loss I know you still feel at his untimely passing. But one of the noble things about outstanding judges is that they live on. They live on in their recorded judgments that are repeatedly cited and followed. They live on in the manner in which they influence the shape and trajectory of the law. They live on in the wonderful example they set for their children, for their peers, and for members of the legal profession. Lord Macfadyen surely lives on, and he will, I'm sure, continue to inspire many lawyers and judges for generations to come. I'm truly honored to give this lecture in his memory, and I thank the Scottish Council of Law Reporting for affording me this tremendous privilege. I'm also extremely grateful for all that has been done to accommodate my wife, Marilyn, and me. We are extremely appreciative of the wonderful hospitality that has been extended to us. This is not my first visit to Scotland, and I have to say that on each occasion I've visited, I've always been struck by the warmth and friendliness of the Scottish people. This year, in a few days actually, the court on which I sit, the Caribbean Court of Justice, the CCJ, celebrates its 20th anniversary. 2 decades are a short time in the life of an institution that has no predecessor. Many of you may not have previously heard of the CCJ, and so I thought that in lieu of attempting to expound on some esoteric or novel area of the law, I would take this opportunity to provide information about my court, how and why it was conceived and established, how it functions, the challenges it faces, and also give a taste of the jurisprudence we have been fashioning. A bit of background to its establishment is helpful. Those of you who follow the game of cricket would know that among the teams that play that sport at an international level, there is only one which comprises players of several different nationalities, the West Indies. There was a period in the 1970s and 1980s when the West Indies cricket team was utterly unbeatable. But now, sadly, our fortunes have changed, and if some have their way, the West Indies will be relegated to a second tier of Test cricket. For a brief period, the West Indies were off the field of play, politically united as one, in a fractious West Indies federation that embraced 10 Anglophone Caribbean islands. The primary goals of the federation were to achieve political independence from Britain as a single state, and to promote the economic development of the member islands. A feature of the Federation was a specially created federal Supreme Court consisting of a Chief Justice and 5 other territorial Chief Justices. Interestingly, that court system also included the then colony of British Guyana that had not joined the Federation. The Federal Supreme Court functioned as an intermediate appellate tribunal hearing appeals from the individual colonies. It was a very highly respected court. The Federation, unfortunately, lasted a mere 4 years. The weight of political divisions, severe economic disparities among the member countries, and an ill-conceived structure were too much to bear. The federal government had very limited powers. Each of the 10 islands functioned as a separate economy. The smaller islands were afraid of being overwhelmed by the economies of those that were larger. The bigger islands considered that the smaller ones would be a huge economic burden. In 1961, a majority of the electorate of Jamaica, the largest and most populous of the 10 islands, voted at a referendum for Jamaica to exit the Federation. The Prime Minister of Trinidad and Tobago, the second most populous country, famously declared that 1 from 10 leaves not. Both Jamaica and Trinidad proceeded to political independence from Britain in August of 1962. And that was the effective end of the federal experiment. Never mind that the West Indies cricket team, under a new charismatic captain, Sir Frank Worrell, was precisely at that time playing the best cricket it had till then ever played. Over the next 20 or so years, almost all the remaining islands that once constituted the Federation proceeded to independence as separate mini-nations. Cricket is not, by a long stretch, the only thing that Anglophone Caribbean countries share in common. We inherited from England not just the language we speak, but also a Westminster-style parliamentary system, the English common law method, and a range of political and constitutional conventions that were transplanted to the colonies. Many of these legacies are today captured in and carefully circumscribed by parameters and values enshrined in our respective national constitutions and post-independence domestic statutes. Unsurprisingly, the dream and goals of Caribbean integration survived the dissolution of the Federation. Regional institutions are continually being built to deepen functional cooperation among the various states. To cite only a few examples, the smaller islands have formed the Organization of Eastern Caribbean States, which is an intergovernmental pact whose members share in common a central bank, a currency, a court structure, and a single Chief Justice that presides over a single itinerant court of appeal. The University of the West Indies, UWI, established in 1948 as a college of the University of London, gained full university status in 1962. I obtained my Bachelor of Laws degree at its Faculty of Law, which commenced operations in 1970. The Council of Legal Education, a regional body currently operating law schools in 3 different Caribbean states, began graduating lawyers in 1975. The Caribbean Development Bank was established in 1969 to support the economic growth and development of the Caribbean countries. In 1972, the Caribbean Examinations Council was established to provide educational certifications in place of the General Certificate of Education exams, which I did as a teenager. I believe your equivalent is the Scottish Qualifications Authority. In the wake of the breakup of the Federation, at an interstate level, there was also established first the Caribbean Free Trade Association, CARIFTA. In 1973, CARIFTA was upgraded to the Caribbean Community and Common Market, CARICOM, which was established by the Treaty of Chaguaramas. And then in 2001, the CARICOM Treaty was revised with a view to establishing a Caribbean Community Single Market and Economy. The full members of the Caribbean Community are now Antigua and Barbuda, the Bahamas, Barbados, Belize, the Commonwealth of Dominica, Grenada, Guyana, Haiti, Jamaica, Montserrat, St. Kitts and Nevis, and St. Lucia, and St. Vincent and the Grenadines, Suriname, and Trinidad and Tobago. The revised treaty was accompanied by an agreement establishing the Caribbean Court of Justice, which was signed by the member states of the community. The countries of the Bahamas, Haiti, and Montserrat are members of the community, but not signatories to the agreement establishing the court. The court was constituted with two different jurisdictions: an international or original jurisdiction, whose remit is to interpret and apply the revised treaty, and an appellate jurisdiction to substitute the court for the Judicial Committee of the Privy Council. The agreement's provisions obliged member states to delink from the Privy Council, to cease sending their final appeals to the Privy Council, and to send them instead to the newly established Caribbean Court of Justice. Some governments entered a reservation to those provisions. Interestingly, neither Trinidad and Tobago nor Jamaica entered any such reservation. As a matter of international law, therefore, those two most populous Anglophone Caribbean states are committed to sending their final appeals to the CCJ instead of to the Privy Council. Suriname, a civil law jurisdiction, is one of the few states that entered a reservation to these provisions for the obvious reason that in its appellate jurisdiction, the CCJ is established as a common law court. Suriname, however, like Trinidad and Tobago and Jamaica, participates fully in the international or original jurisdiction of the court. The agreement establishing the CCJ states that the court was conceived as a further step in the deepening of the regional integration process, with a mandate to play a determinative role in the further development of Caribbean jurisprudence through the judicial process. The agreement makes provision for a president and 9 other judges, but from inception in 2005, the workload has only necessitated the appointment of 6 judges plus the president. For substantive hearings, the court would usually sit with a panel of 5 judges, but on occasions, and in particularly important cases, all 7 judges may sit. The original or international jurisdiction, so-called, because we call it original because it is in contrast to our appellate jurisdiction, that jurisdiction fills a crucial gap that previously existed in the treaty arrangements among the countries that are participant in the community. Under the original Treaty of Chaguaramas, there was no legally binding mechanism to compel member states to fulfill obligations they had undertaken. Those obligations were either voluntarily implemented or, with impunity, not at all complied with. Under the revised treaty, however, the CCJ is vested with compulsory and exclusive jurisdiction to hear and determine disputes concerning the interpretation and application of that treaty and to render binding judgments. Those disputes may be between or among member states, or between member states and the community, or there may be cases brought by a national of a member state to pursue or to vindicate a right that is accorded to each national by the treaty. so as to ensure consistency and uniformity in its interpretation and application. The revised treaty requires national courts and tribunals to refer to the CCJ for determination any question arising before them in proceedings where interpretation or application of the treaty is necessary for resolution of the municipal proceedings. The function of the court in the original jurisdiction loosely approximates that of the Court of Justice of the European Union. Several provisions of the revised treaty were actually borrowed from the European Free Trade Agreement. Other provisions, especially those involving the movement of factors, were inspired by, if not borrowed from, analogous provisions of the EU Treaty and the World Trade Organization. In its original jurisdiction, therefore, the CCJ frequently cites judgments of the Court of Justice of the European Union and of the WTO Appellate Panel. Unlike the case in the appellate jurisdiction, in the original jurisdiction, there is no room for dissenting opinions, as the court has imposed on itself a rule that it will, in each original jurisdiction judgment, render a single opinion. In its appellate jurisdiction, the court serves as the final court of appeal for those CARICOM states which, in compliance with their treaty obligation, have altered their national constitutions to adopt the court as a final appellate court. Currently, 5 states, Barbados, Guyana, Belize, the Commonwealth of Dominica, and St. Lucia, have done so. In the appellate jurisdiction, the court functions much like any common law supreme or final appellate court does. The judgments of the court are enforceable in the same manner as municipal judgments are. Separate procedural rules govern respectively the original and the appellate jurisdictions of the court. The CCJ agreement entered into domestic law by the member states, enacted into domestic law by the member states, has given the rules of court the force of law. As a rule of thumb, the court undergoes a review and revision process of its procedural rules every 2 years or 3 years to ensure that they are consistent with efficient and best practices. Impressive measures, if I may say so, have been instituted by the member states to guarantee both the institutional and judicial independence of the Caribbean Court of Justice. The judges enjoy security of tenure until the age of 72, but upon application, their terms may be extended to age 75. The president serves a non-renewable 7-year term or until the president achieves the age of 75, whichever is sooner. Judges are selected by an 11-member Regional Judicial and Legal Services Commission. The commission is chaired by the president of the court and comprises persons selected by or drawn from regional bar associations and law schools, from judicial service commissions, from public service commissions, and from civil society generally. The judges are recruited on a competitive and merit-filled basis. Vacancies are widely advertised, and applications are received from individuals from within and outside the region. The Commission compiles and interviews those on a short list before making a final selection. Most judges are naturally Caribbean nationals, but a judge need not be a Caribbean national to be appointed. An appointed judge must, however, reside full-time in the Caribbean. Among the first cohort of judges selected, there was an Englishman, David Hayton, and also a Dutch judge. The latter, Justice Jacob Witt, tragically developed an aggressive form of cancer while still in service and died a little over a year ago. The president of the court is appointed by the vote of 3/4 of the heads of government of CARICOM member states after a nomination is first submitted to them by the Commission. The heads of member states are not entitled to consider a candidate of their own choosing. Here too, any vacancy is advertised and the Commission carries out the same process as with a candidate for the office of Judge of the Court. The financial independence and autonomy of the Court are secured through a rather novel mechanism. In lieu of annual subventions from member states, the Court was at the outset provided with a US $100 million trust endowment secured with monies raised by the Caribbean Development Bank. These monies were turned over to a group of trustees whose sole role is to invest the funds prudently. The idea is that the yield on this investment should be sufficient to defray the operational budget of the court over an indefinite period. The US $100 million raised by the bank was repaid to the bank over time by the member states in a manner agreed among them, roughly proportionate to the GDP of each member state. The obligation to repay was premised solely on a member state's participation in the original jurisdiction of the court, so that those states that still send their final appeals to the Privy Council in London had the same obligation to repay as those that delinked from the Privy Council. The upshot of these arrangements is that the CCJ is simultaneously guaranteed of its funding while not being required to interface with the political directorate of any of the states of the region on matters relating to the financing of the court. These arrangements have worked remarkably well. As a self-contained international organization, unlike municipal courts, the CCJ is required fundamentally to handle or arrange for itself all its non-adjudicative and administrative matters, including its financial, protocol, human resource, communications, logistics, IT, training, and security issues, among others. The price of such welcome independence and autonomy is the necessity to undertake enormous responsibilities over which the President has ultimate oversight. The Court and the Commission have therefore placed great emphasis on the development of internal mechanisms to optimize good governance. To this end, the Court's operations are strategically directed and heavily policy-laden. 5-year strategic plans have been devised as dynamic tools to guide the court in continually improving its delivery of justice, adapt to challenges, build internal resilience, and enhance operational efficiency and stakeholder access. A monitoring and evaluation committee oversees adherence to the strategic plan. Since 2022, the court has been an implementing member of the International Consortium of Court Excellence, an organization of judiciaries, judicial institutions, and affiliated bodies from various parts of the world. The consortium actively promotes court excellence, principally by publishing, continually revising, and encouraging the use of a framework that enables courts to measure their performance against internationally recognized benchmarks. The framework utilizes a methodology that features continuous self-improvement through a cycle of self-assessment, planning, implementation, and evaluation. The court strives faithfully to follow this approach to its non-judicial work. As the region's apex court, the CCJ is ever conscious of its obligation to set high ethical and operational standards that provide an example for other courts in the region. The court publishes on its website an annual report which summarizes the judicial and administrative work undertaken throughout the period under review. The report includes court performance data as well as audited financial reports. The court, in conjunction with the Commission, has also developed a raft of policies to govern various aspects of court administration and staff and judicial conduct. These policies support a rules-based environment that conduces to transparency, accountability, fairness, and consistency. They also serve to provide clear guidance for judges and staff. Notable policies of relatively recent vintage include the third iteration of the court's Judicial Code of Conduct, a harassment policy, a policy aimed to improve access to justice for persons with disabilities, and a policy on the use of artificial intelligence. The Commission plays a huge role in fostering this rules-based approach. It also provides financial oversight of the court's budgeting and expenses, as well as its human resource practices. The CCJ maintains a warm relationship with several international bodies, including, for example, the Inter-American Commission on Human Rights and the Inter-American Court on Human Rights. We also naturally enjoy a fraternal relationship with the judicial officers and municipal courts of the English and slightly less so the Dutch-speaking Caribbean. Three main vehicles help to nurture this relationship. The first is the Conference of Chief Justices and Heads of Judiciaries of Caribbean countries, which meets annually. The conference serves as a platform for regional collaboration on judicial matters and the sharing and exchange of good and innovative practices. When Global Affairs Canada was moved to provide financial assistance to Caribbean judiciaries to the tune of 20 million Canadian dollars, the Judicial Reform and Institutional Strengthening Project was executed by the court for and on behalf of and in close collaboration with the heads of judiciaries of Caribbean countries. Not long after the CCJ was established, the heads of judiciaries conceived the idea of establishing a Caribbean Association of Judicial Officers as a complement to the CCJ. CAJO, as it is fondly called, facilitates Caribbean judicial officers of all stripes to take advantage of opportunities to network, to fraternize, and to collaborate in the building of a Caribbean jurisprudence reflective of our culture and our society in general and the common values laid out in our respective national constitutions. To this end, CAJO organizes continuing educational programs that enhance the knowledge and skills of judicial officers in areas such as the use of modern court technology, judicial integrity, judicial well-being, gender sensitivity, appropriate dispute resolution, court administration, and efficient judicial processes. The CCJ's role in sustaining CAJO has been critical. We provide that association with indispensable logistical and administrative support, and from its inception, the association has been led by a judge of the CCJ. The court has also created the CCJ Academy for Law as its own vehicle to pursue initiatives and programs that showcase the place of law in economic and social development. The Academy has played a huge role in recognizing and celebrating the contribution of eminent jurists to the development of the Caribbean legal landscape. One of the Academy's main interests at this time is fundamental reform of the criminal justice system in the Caribbean. And to this end, the Academy convened a major conference in Barbados in 2022 that was attended by a wide variety of high-level representatives of the various bodies that play a role in criminal justice. As we understood that here too in Scotland, you have also been engaged in similar reform initiatives, we were very pleased to have Lord Beckett join us on that occasion to deliver a paper on pretrial proceedings, enforcing time limits, and active case management. That conference culminated in the adoption of a declaration that contains 39 recommendations for criminal justice reform. The litigants who come before the Caribbean Court of Justice hail from as far north as Belize in Central America to Suriname and Guyana in South America. And then, of course, there is Jamaica and several islands of the Anglophone Caribbean. The court's commitment to affording the highest quality of service at an affordable cost for these stakeholders motivated us at an early stage to invest heavily in the innovative deployment of modern information and communication technology. Many of the court's systems, including its core court and judicial operations, are paperless. Electronic filing was first introduced in 2013 and electronic case management implemented in January 2017. By providing 24/7 access to stakeholders, e-filing eliminated a variety of constraints imposed on litigants by geographical boundaries and fixed daytime court hours. Our e-filing and digital case management systems have allowed for efficient management and easier statistical analysis of filed cases. Video conferencing, live streaming, and virtual hearings have complemented e-filing and digital case management. Many litigants and their lawyers are content to have their cases heard online, as this offers them greater convenience and economy. The public at large can view our hearings in real time on the court's YouTube platform. By eliminating the need for both physical travel to the seat of the court and the use of paper, adoption of these technologies aligned fully with the court's Go Green initiative to encourage and promote environmentally friendly practices. Deployment of these modern technologies permitted the court to maintain business continuity in a seamless manner during the COVID-19 pandemic. Most of all, these technologies contribute to the arduous task of building and sustaining public trust and confidence in the region's apex court. With the rapid evolution of artificial intelligence, the court has partnered with the Caribbean Agency for Justice Solutions to explore the potential benefits of generative AI. This has resulted in the development of an AI tool the court refers to as Ask CCJ. The tool has been trained specifically on our judgments, on our court procedures, our rules, and papers and speeches delivered by our judges. Use of this tool, which as of now is restricted to internal stakeholders, lightens the workload of our judges and research assistants. I hope I have not painted too rosy a picture of a court that actually faces important challenges. The main challenge faced by the court in pursuit of its mandate is the relatively modest uptake in cases filed in both the original and appellate jurisdictions. The reasons for this are varied. In the original jurisdiction, the bulk of the legal fraternity in the Caribbean is not particularly experienced in litigation that is based on international law, international trade law, economic community law. They are often, therefore, not particularly alert to advise on or exploit potential opportunities for advancing the causes of their clients in matters related to the revised treaty. Municipal judges, on the other hand, have not referred any of the few disputes that have come before them which could benefit from an interpretation by the CCJ of this or that provision of the treaty. To try to address this problem over the last 2 years, the court has been hosting a series of seminars with these stakeholders and with the business community in order to explain the provisions of the revised treaty, the rights it confers on Caribbean nationals, and the role of domestic courts in the implementation of that treaty. Funding for that project has been generously supplied by the European Union. In the appellate jurisdiction, the question that is always asked of us is, why has less than 1/2 of eligible Caribbean states altered their constitutions to accede to the appellate jurisdiction of the CCJ. Why don't the other states also send their final appeals to a court for which their tax dollars have handsomely paid? The reasons here are also varied. One of them is that there are extraordinary constitutional hurdles that must first be overcome in some states. The states of Grenada and Antigua and Barbuda, for example, have been saddled with independence constitutional provisions that absolutely require those governments not just to obtain a qualified majority in Parliament in support of the measure, but additionally to garner a two-thirds vote at a popular referendum. On 3 separate occasions, the governments of these states easily obtained the qualified parliamentary majority, but on each occurrence, the measure failed at the level of the popular referendum. In Jamaica, where the Constitution does not ostensibly prohibit Parliament by ordinary majority from so altering that country's constitution, when the Jamaica Parliament did so in 2004, using a bare parliamentary majority, the Privy Council, overriding the local courts, voided the measure by implying into the Constitution the need for at least a qualified parliamentary majority vote. Quite apart from the objective constitutional hurdles, there are other factors at play. In any country, only an extremely small number of cases ever reaches the final appellate court. In the countries that have not yet acceded, the mass of people still know relatively little of the court or fully appreciate its seminal value to the development of Caribbean society and Caribbean jurisprudence. Many consider that there are far more important bread and butter issues with which their government should concern itself. It is also true that in spite of the impressive institutional and administrative measures employed by the court to ensure transparency, access to justice, and judicial independence, some people still consider that British justice will always be purer. Regrettably, such thinking is also a legacy of colonialism. To be fair, though, generally speaking, there is not the highest regard for municipal and state institutions in the region by masses of people. Only the countries of Barbados, the Bahamas, St. Vincent and the Grenadines, and Dominica joined the United Kingdom in ranking in the top 20% of Transparency International's 2024 Corruption Perception Index. And many persons make no distinction between the CCJ, a self-governing international entity, and local municipal institutions. Mixed messaging from London has not helped. Consider these 2 related questions. In principle, is an independent, well-staffed Caribbean court the most suitable vehicle for determining Caribbean final appeals? Are the UK's top judges spending an inordinate amount of their time in the Privy Council hearing appeals that should ideally be heard by a Caribbean court that has been established specifically to hear those appeals? It might surprise you to learn that since the agreement establishing the court was signed, fulsome but contradictory answers to these straightforward questions have been publicly advanced by the most senior British judges. For my part, the most important roles of a final appellate Caribbean court are to protect and advance democracy and the rule of law, and to expound the country's written constitution. In fulfilling these roles, it is often necessary to tackle difficult or grey areas of the law, and in the process, to weigh and to settle on one of almost equally persuasive contending views. Appropriate resolution of these grey areas necessarily involves judgment and an element of judicial policy making. Law, after all, is not mathematics, and a written constitution is not to be interpreted as one might a tax code. Construction of a constitution cannot be divorced from its social, environmental, and cultural context and a deep appreciation of its historical roots. Judges who are naturally alienated from the pulse of a society, from the narrative that guides and animates that society, and moreover, who do not personally experience the consequences of the decisions they make, are not ideally positioned to offer binding prescriptions to govern that society. What of the jurisprudence of the CCJ? We have heard some roughly 40 cases in the original jurisdiction and approximately 400 in the appellate jurisdiction. In one of the first cases that we heard in the original jurisdiction, we grasped the opportunity to make clear that under the revised treaty, member states of the community are now operating under a regime that is quite different from the one that prevailed under the original treaty, where there was a voluntary system of compliance with agreed undertakings. We stated then that, and I quote, by signing and ratifying the revised treaty, and thereby conferring on this court ipso facto a compulsory and exclusive jurisdiction to hear and determine disputes concerning the interpretation and application of the revised treaty, the member states transformed the erstwhile voluntary arrangements in CARICOM into a rules-based system, thus creating and accepting a regional system under the rule of law, unquote. In another case brought by a cement manufacturer against the state of Guyana, the court clarified the circumstances in which private entities were entitled to commence proceedings. In that suit, brought by nationals respectively from Trinidad and Tobago and Guyana, the defendant state of Guyana argued that it was not permissible for the second claimant to sue its own state. The court held essentially that the revised treaty's provisions on non-discrimination took precedence, and the Guyanese claimant could not be placed in a position that rendered it less advantageous in pursuing its rights than its Trinidadian co-claimant. Several of the cases in the original jurisdiction concern such matters as the imposition or failure to impose applicable tariffs, economic policies that affect regional trade, or disputes where CARICOM nationals are denied their right to live, work, or travel freely. Almost all of the cases filed in the original jurisdiction have been brought by private entities or individuals. It was therefore very pleasing when the court received a request from the community and several states to render an advisory opinion on the interpretation and application of certain articles of the revised treaty. In its appellate jurisdiction, the court is perhaps best known for its judgments that advance the rule of law and address circumstances where litigants seek redress for alleged breaches of their constitutionalized rights. An interesting case we heard early on was from Barbados, where the critical material linking an accused to a homicide was the evidence of a dentist. The accused was arrested very shortly after discovery of the lifeless body of the victim in a wooded area. The dentist was allowed to see the accused while the latter was in custody. The dentist informed the police that a wound on the arm of the accused resembled a bite mark. The dentist then examined the body of the deceased woman, the oral cavity, the dental cavity, and his further investigations and measurements convinced him that not only was the accused wound a bite mark, but that this particular bite mark could only have been made by the deceased. Now, bite mark evidence belongs to a highly specialized scientific field called forensic odontology. Some controversy surrounds its reliability as compared with, say, fingerprint or DNA evidence. The dentist was not himself a forensic odontologist, but his bite mark conclusions were effectively the only solid evidence in the possession of the Director of Public Prosecutions. The accused, insisting on his innocence, invoked the provisions of the Barbados Constitution that are analogous to the right to a fair trial set out in Article 6 of the European Convention on Human Rights. He demanded that the state provide him with the funds to retain a forensic odontologist as part of his right to facilities for the preparation of his defense. The court disagreed with the applicability of this particular premise for invoking his right to a fair trial. Bearing in mind, however, that the accused was a man of very limited means, facing a possible death sentence, the court concluded that a fair trial could only be guaranteed if he was placed in a position to test the evidence being adduced by the state. We therefore instructed the state that it either had to pay for the services of a forensic odontologist to assist the defense, or else they had to stay the proceedings against the accused. The reasoning in the judgment was carefully calibrated to forestall the opening of the floodgate. In the case of Lucas against the Chief Education Officer of Belize, I noted in my opinion that, quote, the constitutional right to protection of the law may successfully invoked whenever the state seriously prejudices the entitlement of a citizen to be treated lawfully, fairly, or reasonably, and no cause of action is available effectively to assuage consequences to the citizen that are deleterious and substantial, unquote. This approach to granting relief for breaches of the rule of law has since been adopted in a few of our judgments. Perhaps the most memorable was the case of the Maya Leaders Alliance against the Attorney General of Belize. The Belize National Assembly, commendably, had altered that country's constitution in 2001 to include in the preamble the obligation of the state to adopt policies which protect the identity, dignity, and social and cultural values of Belizeans, including Belize's indigenous peoples. The Belizean courts took up the mantle and, partly on the strength of this amendment, have recognized the rights and interests of the Mayan community in southern Belize to their customary land tenure. In the celebrated Maya case, the CCJ held that as part of the court's duty to afford the Maya their right to the protection of the law, the state of Belize had a responsibility to take positive steps to recognize and protect Mayan indigenous land rights. Our judgment required the government to engage in a range of complex measures designed to satisfy the reasonable interests of the local Mayan community. Since delivering that judgment in 2015, the court has presided over regular hearings to monitor compliance with the intricate undertakings required of both the state and the Maya in order to realize the substance of the judgment. Generally, the court's jurisprudence is consistent with that fashioned over the years by the Judicial Committee of the Privy Council. There is one area, however, in which our jurisprudence has diverged. It has to do with the interpretation of a clause called the Savings Clause found in the constitutions of certain Caribbean states. In isolation, read literally or textually, the clause appears to preclude the courts from invalidating any existing law first enacted during the colonial era, with little or no regard to whether the law deprives the citizenry of their fundamental rights. The issue of appropriate interpretation of the Savings Clause repeatedly came before the Privy Council in the early noughties in relation to the mandatory death penalty for murder. In most independent Caribbean states, that punishment is contained in a law first enacted during the colonial era. Everyone now accepts that this punishment is arbitrary and inhumane, not least because of its automatic character, coupled with the grave and irrevocable consequence attending its execution. The question is whether the Constitutional Savings Clause has the effect of saving this penalty and all other colonial laws from being declared by courts to be unconstitutional. In 2004, the Privy Council assembled a 9-member bench in the combined hearing of the cases of Watson, Matthew, and Boyce to determine finally this question that had generated great controversy and contrasting Privy Council judgments. A bitterly divided Privy Council ultimately decided 5-4 to interpret the clause at face value. Writing for the majority, Lord Hoffman preferred to read the clause literally. He determined that if and when colonial laws were found to be inconsistent with the rights and freedoms that were declared in the Constitution, it was for Parliament and not the courts to provide the remedy. This decision produces interesting practical consequences. It has the effect of creating a curious double standard. If a statute was enacted during the colonial era, the Savings Clause effectively hobbles the court in the carrying out of its duty to afford effective relief to persons whose human rights are infringed by that law. If, however, the fundamental rights of the citizen are infringed by a statute enacted in the post-independence period, courts are under a specific duty to modify or to render void the post-independence law so that the fundamental rights of the citizen are secured. In a trilogy of cases, Nervez, McEwan, and Bisram, the CCJ respectfully differed from the view of the Privy Council majority. In somewhat strident language, the CCJ stated in Nervez that interpreting the Savings Clause in the way in which the 2004 Privy Council majority did evinces, I quote, an unacceptable diminution of the freedom of newly independent peoples who fought for that freedom with unshakable faith in fundamental human rights. The idea, even where a provision is inconsistent with a fundamental right, a court is prevented from declaring the truth of that inconsistency just because the provision formed part of the inherited laws from the colonial regime must be condemned. It seems to me that at the heart of the divergence lies profound differences in our respective understandings of the essence of Caribbean constitutionalism, of the meaning and consequence of independence, and of the manner in which judges can and should deploy the range of tools that are available to interpret a written constitution in a purposive manner. Political independence and the constitutions that usher in the same represent, in some respects, a continuation of governance systems and structures. Save Guyana, the parliamentary and electoral systems, for example, for the most part, are inspired by Westminster. But it is also true that in important respects, Caribbean constitutions herald a break from the colonial past. These constitutions proclaim deep-seated values that were not always manifest during the colonial period. They proclaim with pride the citizenry's right to enjoy in peacetime certain fundamental rights that are laid out. These constitutions exalt self-determination. They break with British tradition in that they are not premised on parliamentary supremacy. In most constitutions, Parliament, even when it acts unanimously, is incapable of enacting certain legislation without the support of the people in a popular referendum. In each of the constitutions, responsibility for protecting the rights of the citizenry is specifically entrusted to the judiciary, which is authorized in appropriate instances to constrain both legislative and executive acts. Neither parliamentary inertia, for which there may be myriad explanations, nor parliamentary indifference to the harmful consequences of an existing law provides, in my respectful view, justification for constitutional interpretation that precludes courts from affording effective remedies to persons affected by laws that trample on constitutionalized human rights, irrespective of when those laws happen to have been enacted. The respective appellants in the 2004 Privy Council cases of Watson, Matthew, and Boyce were all seeking to avoid automatic death penalties for murder, for which they had been convicted. It would have been unfortunate enough if the precedent set by those cases concerned only the constitutionality of the mandatory death penalty for murder. Immunizing pre-independence laws from human rights challenges, however, goes well beyond persons found guilty of murder. Throughout various parts of the Anglophone Caribbean, colonial laws remain on the statute books that, to cite one example, justify and reinforce a climate of intolerance of and even hostility towards the LGBTI community. Given that notorious climate, Parliament is hardly likely to be an institution that will boldly step in to protect the rights of persons who fall within that vulnerable minority. Legislatures are not always quick to address very contentious issues when only a minority is affected. The reasons are varied. Sufficient votes in the Assembly may not be available. There may be vociferous opposition from influential conservative or religious groups. Legislators may fear political backlash. In circumstances such as these, parliaments are often content for courts to take the heat by doing what courts are called to do, rendering without fear or favor justice according to law. And true to form, in recent times, trial judges throughout the region have been striking down sodomy laws enacted during the colonial period, and the state has rarely appealed these decisions. In conclusion, I believe it says something for the vitality of the rule of law in the Caribbean that all the judgments of the CCJ have been fully and promptly complied with, especially given that in not a few of those cases, incumbent governments were on the losing side of the litigation, and the orders made by the court must have been very, very bitter pills to swallow. Despite our judgments, the CCJ remains resilient and optimistic. The judges and staff of the court are fully cognizant of the fact that the establishment of the court is perhaps the most impactful decision ever made by the Caribbean community. We see ourselves as stewards, as should be the case in a well-functioning democracy. Through our decision-making, a healthy dialogue takes place between the court and the parliaments of the various states. In not a few instances, legislatures have enacted new or amended existing legislation and legal procedures to accord either with our judgments or intimations contained in those judgments. No court anywhere in the world can honestly state that it has attained a state of perfection, but every court must continuously aim for perfection. A court is one of excellence if it always so strives. And in this regard, the CCJ makes every effort to live up to its vision to be a model of judicial excellence. Esteemed colleagues, ladies and gentlemen, this has been an enormous privilege, and I thank you for your very kind attention, and I reiterate my gratitude to the Scottish Council of Law Reporting for affording me the signal honor of addressing you on an occasion such as this. I thank you.